crux of his evidence was that he and Mr. Rojo Metonunu were deceived by the EC chair with an instruction to leave the EC premises during the collation. And upon further cross-examination, he admitted that the EC chair could not actually instruct them so to do. We have been waiting for the evidence or further witnesses who will provide evidence that nobody crossed the 50% mark. This is the government of their case. Today, we were seized, or the court was seized with an application that was filed yesterday. And I heard our colleagues who just left say that this has been there for a while. It's not true. Check the date on the application. This application was filed yesterday. This application was filed yesterday. In fact, it was filed. It was served on us yesterday, but it was filed the day before. So this claim that this application had been put in way ahead of time is not true. That's why you heard our counsel talk about 34 days after the initial application. But be that as it may, this application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation, but it is not a matter that you have as of right. It is at the discretion of the court, and you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity for you to be given leave to inspect those documents, because among other things, it will be necessary for the fair disposal of the matter. Without it, there will not be a fair disposal of the matter. And that it may also be necessary to reduce the cost of litigation. You heard Mr. Chachuchikata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there is anything wrong with the copies that he has, and therefore asking to inspect the originals, because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondents or the defendants to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent. And they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. Said the applicant has not demonstrated the necessity that must be met. In that, indeed, on record, they have admitted that they have the documents. No proper case has been made for this application, which we have spent a number of hours on today. And if you look at section, I think 166 of the Evidence Act, they have not raised issues of authenticity even. And therefore, it is not the 1 hour, submissions and English that would invoke the court to exercise its discretion in this matter. You must ground it in law and prove same. We are of the view that the pendulum swings back to the petitioner, who had advertised that he has 5 witnesses who will give evidence to show that nobody got 50%. We've heard the first 2. The jury is out on that one. If there are 3 other witnesses, now will be the good time for them to either submit those witnesses to adduce this evidence that shows they are supporters that they told they had won and then they came to change the story, but that will show them that indeed nobody won. Or if they are not able to put further witnesses before the court, then they would have to bring down their case, and then the respondents will also have to now move to their next line of action. We think it's generally been a good day in court for justice, and we look forward to the directions of the court on Friday.
So, Mr. Minister Designate, Mr. Opong Nkrumah, 2 questions. The first one is that we've noticed that in court, most of the time, the petitioner's side is doing very long arguments, whereas the respondents, both you and the EC side, do very little arguments. What's accounting for this? And again, every time we've come to court when there's an adjournment, the Chief Justice will indicate what will happen next in the next sitting. This adjournment, there is no such indication. Can you give us some indication as to what we should expect at the next sitting?
I mean, obviously, you saw the bench invite lead counsels into chambers and have a set of conversations with them. We were not in chambers. We were not privy to it. It was something that obviously they did not want to advertise in open court. I am sure that that has an influence on the adjournment and the directions for Friday, but we are not in a position to say because we were not in there. We'll look forward to whatever the Honorable Court will put out on Friday. But to your first question, yes, as a matter of fact, you notice that counsel for the petitioner sometimes has about an hour. In fact, today you noticed from about 9:30 something to about 10:30 thereabout on his feet making arguments. And counsels for first respondent and second respondent are very crisp in their responses. It is because this is a court of law, not a court of public opinion. When you make an application before the court, you must satisfy what the law requires and back it with authorities that are relevant or the legal invocations that are relevant. For example, if you recall the application for leave for supplementary, counsel for the petitioner was on his feet for several minutes, but if you listen to the ruling of the court, it says that even the authority that you cited, Elistamaklu, has nothing to do with supplementary applications of this nature. And the expectation that you will give us good law to back your application did not happen. So we are not invoked. Counsels on our side, you would notice, are limiting themselves to the law and the legal requirements, are not necessarily arguing with the bench, and are speaking to matters of law. So what does the law say? That is what we are interested in arguing. So if under CI 127, under Rule 44, there's a clear provision that forms are set out and must be made available to all parties. All we need to do is to invoke that. We don't need a lot of grammar to make our case. And that's why you would have noticed that we are not spending too much time speaking English, but we're speaking law.
Being a journalist yourself, you understand how we get when we don't get the information we seek. So, follow up to his one of his questions. Do you have and can you help us with any indication as to what would happen on Friday when the court reconvenes?
I cannot, because as I've mentioned, we were not in chambers with the judges. We are expecting, and if you look at the natural flow of this case, we're expecting the petitioner, because the law says he who alleges must prove. The petitioner has told us that he has 5 witnesses who will prove, among other things, that nobody got 50% and that we should go for a runoff. Not so. The petitioner has put 2 witnesses in the box who have been cross-examined. We are expecting that the petitioner ordinarily will call the other 3. The petitioner today brought an application which was filed just in the last 48 hours, which application is what has consumed our time. And our expectation is that the petitioner will either continue with the 3 other witnesses or inform the court that they intend to bring down their case at this point for the respondents to now also move whatever submissions that they may have. Intervening in these two is this new application that they brought, the Chambers hearing, and the direction that we should come back on Friday. So we'll wait on Friday and hear what the court has to say.
Mr. Minister Designate, the petitioner spokespersons said that they don't have copies or carbon copies of this Form 13. May I know if you have one and why they don't have one?
So you should listen clearly to the court. You see, sometimes when we come to court, it's not what counsel on our side says or what counsel on the other side says, because lawyers and witnesses can say so many things. In the end, it is what the court finds. And if you heard the court clearly, the court started off by invoking CI 127 Rule 44, where copies are made available, and proceeds to say that the court is clear in its mind that all of those documents are available to the petitioner, and I dare even say by extension to all other parties who participated in this election in accordance with the law. That's been the very clear finding of the court and ruling accordingly.
Mr. Nkrumah, your side has always held from the very beginning that...
I'm sorry, I can't hear you very well.
I'm saying your side has held from the very beginning that the petitioner has no case. You have told us that they've gone through their witnesses. They finished with two of their witnesses who provided two witness statements. You also cited the High Court procedures of how when applicants make a case and they send witnesses through and they are done, what happens next? Will your side file a submission of no case on Friday or going forward?
Well, they have not, in our understanding, completed making their case. They have only called 2 out of 5 witnesses. The first one is the one who came in ostensibly to suggest that nobody got 50%. But you saw this witness always calculating and getting 47.51. The second one, who you thought was also coming to provide evidence that nobody got 50%, came in only to say that he heard through Rojo Metil-Nunu that they were instructed to leave, and later admitted that nobody had power to instruct them to leave. As to how that accounts for nobody won 50%, I'm not sure. They have 3 other witnesses that they have informed the court they want to call. So it is at the end of the making of what is ostensibly their case that respondents will take the next line of action.
Primarily, the court asked...
I'm sorry, I'm struggling to hear you, sir.
My right honorable, good afternoon. Primarily, the court asked for more details from the plaintiff, the complainant, that the case was adjourned to the 27th. Now, have the details, all the details been supplied? And is that the reason why there's an adjournment to Friday for a decision? And if all the details have not been supplied, is there a reason for an infraction for continuity at all in this case?
As I've mentioned, I cannot guess the purpose for the court's order of adjournment. We are in the hands of the court. We'll come back on Friday and hear whatever further directions they may have. I want to thank you. After one more question, and then I will invite my colleague to wrap up in 3.
Honorable, this morning, the lead counsel for the petitioner asked a question in court that if the EC's interest is in transparency, then why is this so difficult for them? Indeed, you have on several occasions spoken about the public opinion that the lead counsel for the petitioner appears to be pandering towards public opinion. But public opinion is also very important for clarity. If indeed there is nothing to hide, why are we using the law to prevent the EC from coming up to give sunshine to these matters?
Well, so the EC has already provided sunshine to these matters at the 38,000 polling stations in the country, at the 275 constituency collation centers, at the 16 regional collation centers, and then at the National Collation Center, and has made all those relevant documents in accordance with Rule 44 of CI 127 available to all parties. When you come to court beyond that and you want to invoke the discretionary jurisdiction of the Supreme Court to inspect the so-called originals, there is some legal standard you must meet. The legal standard is not the propaganda question of if you have nothing to hide, why don't you show me? It's not in the law. The law says that you have to show what we call necessity. Necessity to fairly dispose of the matter. And that if it is not done, the matter cannot be fairly disposed of. That you must show that there is necessity to reduce the cost of litigation. As you heard counsel for the petitioner argue, he was not able to satisfy that threshold. So, my dear brother, don't fall for the propaganda argument they make on the side. There's a legal threshold. As you hear them make the argument, for example, like I cited in the earlier one for application for supplementary, there's a legal threshold. You don't fail that one, cite wrong cases, cite wrong authority, and then now throw in a propaganda question that asks them that if they have nothing to hide, why? This is a court of law. So if the court and the law imposes a legal threshold that he who alleges must prove that you satisfy the concept of necessity, you recall in the case of interrogatories, it's not a propaganda argument, it's that why are they not allowing us to ask our question? Why are they not? No. The law says that the interrogatories must be relevant to the issues. So if you ask questions that are not relevant to the issue, you will not be allowed. You don't get to go around making the argument that why are they not allowing us to ask questions? No, the questions must meet the legal threshold. Thank you very much. My colleague would do the tree translation for us.
Abu Janfo, yabada mwase. Ene eye eda etoso enkuno a yeshiawo eye court dem ha. Nene ne yakoso ye nyina ye nim eye petitioner bibia no mo so mu onyina so omo evidence omo onyina so na eye openia sedun ketia a ono ebedi adanse eye ma former president Mahama na no oba betena adakam ye toto na no ye hu se ne nsem ni nyina no ensisi so enron so eye openi pesa white enso ebetena adakam enu so ye nyina ye hu ni ye ko ye se ne nsem ni nyina no atonsuom enti adansidi a omuni enti ene ye de krata ba betu court anim se eye krata omo ankasa omo wo bidada sanse emra no eye CI 127 no ehye isi keten se woto aba no polling station wie na se ye kenkan ye hwegu ho na ye de nyina no egu krata so a eye parties obibio take part bia na musini no eho behia se obenya krata ni bi ebiem se eba constituency nso a emra ne hyeketin se krata na yabunkunta aguso ne ya che obia ema onya ye no eno nso emra ne hye isi keten se obia party bia na musini no ebenya eno nso copy sa ena oba region so a etie ena oba national so a etie eye petitioner eba no wankasa nkratai onya bi onka ba bia sa da awo ne krata odi aba to court mu enne omo say 275 constituencies no yemfa ho krata nyina amnyina ma omo isi emfa ma omo ebiem all the 16 regions no so no isi emfa ho krata nyina ma omo ansa na yeba national so yemfa ho krata nyina ema omo na abusuafo ne ehu hia ye pa ne se sankrata nyina so omo obi dada etiene yi se obehwa kasatintin wo hoy entoponko twene so animu da ho a ye monche mu asempa wo hoy etia etinya kasatintin donhwere no ene nsem a obeka asabia ye ntwanchia no ena eno beka se owo asem etiene wo hwe easy lawyer na wo hwe eye president Nana Akufo-Addo lawyer nsem o mo kan na ginamra no so o mo se sankrata nyina o mo obi ina ebiem nso no o mo hu hia omuntimi enda na di se hu behia se o se wei no ye de ma omo eho ena Supreme Court ekọ ena osabae empanifo bae omu nyina empanifo nso ni nyina adwen ekọ benkrom ena omu nyina se eye saa ensem yi a mo se yemfama mo na mpese mo hwe nkrata mu yi ne edi kan mo wo sankrata ni bi dada ne toso mienu ehu hia no muntimi enkyereye ne toso miensa munsan enka o mu petition ni mu se ekrata no munsan ka etise wokọ eye yemramu evidence act na eye section 166 ede na di pefe sekrata bia ye be mawo ebie send your protocol me kind of carbonized copy no Sakratania de Mawa ni original no ene ni nyina no yepe a court agitum say ya dance here enu nti no court mpanimfo nso yi ebo eye ensem no enyina eguye abusia mamema ni nda na di say ekamia kwa say eye petitioners eye former president Mahama oni dance here into court dem ho no person odi ti ebo bodan mu no pa dance here enti oni dance here nti no nanu yebusa say na mu ankasa mu yem coalition no aya former president Mahama nya say opani asie dun ketia say my lord I have not brought that figure to court chese san kuntabuo no man fa ma court na one so president awugina man so onya say enu so onim na nanado de enso onya say enu so onim na total no so eye say enu so onim enti enne asama ekosi ye no court abo ni nyina egu na asem ba ko esi ya na eni enyan na o se ka ho asem asem bi si no opani chachu asemo kan ni say eye judge penny pa no na asemo kan no eye completely irrelevant questions obusa no wey sa kasa twitwe ahantan kasa asa ye pese ye ka na efu justice for no ebo no eye ade a o se kasetia eye very unfortunate say penny lawyer penny pa wonim de na wutimi ene judge penny akasa asem ni friwa no kraba eye very unprofessional language o say ye ka eti wey ene enema ene ekoso e Supreme Court I was say ye ma munya mu dadi abusuafo e beda mwase na ansa na no mesre san say ye ne mpanifo ene wa ha a lawyer for mu tamachi ene chairman makmenu emu wa ha obapa Joyce enso wa ha lawyer Joyce Boaten enso e wa ha say ena Hajia Fati Abubakar onoso lawyer nipa deputy director office of the president lawyer Nana Ajua Adobia Santi enso ewo ye ha sei ansana eye Evans Nimako ya lawyer for mpanifo mu di animu aye lawyer